Hello and welcome to June's Breaking Barriers LinkedIn Live. I'm Rachel Schofield, Senior Facilitator with Shape Talent. And today, excuse the pun, we are diving into a hot topic. AI is everywhere. But what about AI in HR? If you are using AI in hiring, in performance, in promotion, you need to know all about the EU AI Act. And it is our job today to get you as up to speed as we can, because this is not a future concern. Parts of the Act are already in place and there's more to come. So we're going to be talking about that. I'll introduce our guests in a moment, but first, the elephant in the room. It is hot. Tell me in the chat what temperature it is with you. I've decided, by the way, I want to be in Sweden. I was talking to somebody in a coaching group this morning who was in Sweden. She said it was 21 degrees. I thought that sounds nice. I think it's about 28, 30 here. I'd love to know where you are and how hot it is. Just for my own curiosity, it's got nothing to do with AI, it's got nothing to do with the EU Act, but it would fascinate me because Sharon and Priscila and I are very hot. And if we look a little bit darker than normally on our monthly LinkedIn Lives, I think it's because we've all got the curtains drawn. But anyway, you are most welcome. Let me introduce our guests today. I'm delighted to have with me the CEO and founder of Shape Talent, Sharon Peake. Hi, Sharon.
Oh, nice to be here.
And Priscila Pereira, Dr. Priscila Pereira, who is our Director of Research and Innovation. And together, although I should stress we're not legal experts, but we are very much wrangling with the EU AI Act, together we'll be diving in to what are companies' obligations under the Act, what do HR teams in particular need to know. We'll be talking about gender equity blind spots. We'll be thinking about what leading organisations are doing to make sure that they are turning compliance into a fairer, more consistent talent system. So we're going to be looking at all of those things. Let's set some context first of all. We'll have about half an hour, by the way, and we'll make some space at the end for some questions, ideally. So do as well, use the chat, say hello, tell us how hot you are, and importantly, ask your questions about AI and the EU Act. But Sharon, let me come to you first. In all seriousness, as I said, we're not lawyers, so legal disclaimer. We're sharing what we know. We are getting really interested in this because it is so important. But give us then a quick picture of what the EU AI Act is.
Yes, thank you, Rachel. And as you said, we are definitely not lawyers, so this is our interpretation of the Act. We are still learning, of course, ourselves. The EU AI Act is the first comprehensive legal framework for artificial intelligence in the world, so it's really groundbreaking in that regard. It came into effect 1st of August 2024, and it takes a risk-based approach to managing AI, and it has 4 categories that are really important. First one is things that are prohibited. These are things like emotional regulation tools that, emotional recognition tools that identify or try to identify your emotion, such as using video-based AI. So things like that are prohibited. We'll talk more about that in a little bit. The second category is high-risk AI tools. Recruitment tools falls into that category. We're going to talk more about that. The third is limited or specific risk categories. Things like chatbots, things that we use kind of most days. And then the fourth category is minimal risk. And actually, most AI systems fall into the minimal risk category. So this might be things like any video games that are AI enabled, or the spam filters that we all have on our computers, that kind of thing. So it takes a risk-based approach, and the penalties for non-compliance are really serious. They're really severe, up to 35 million euro, or 7% of a company's global revenue for non-compliance or for breach of the Act. So this is really extreme. It's even more extreme than the GDPR legislation, which takes a percentage of revenue as well. So something that all organizations really need to get a handle on. As I said, one of the categories is prohibited category, and some AI tools and practices have already been banned outright since February 2025. And that includes the emotion recognition systems that I alluded to a moment ago. So in plain terms, if your HR stack includes any kind of facial expression scoring, kind of video interviewing with facial expression scoring, or voice stress detection systems built in, it is unlawful. And there was a pretty big case of this. One of the big vendors, HireView, one of the largest AI video interviewing platforms, used by lots of companies around the world, JP Morgan, Goldman Sachs, IBM, Unilever, and so forth. They previously used a bit of technology from another provider to analyze facial movements and to generate employability scores. So they stopped doing that a couple of years ago. They don't any longer have that as part of their tool. And it is unlawful. That's the reason they stopped doing it. It is unlawful under the Act. So really important to know what you can do, what you can't do. Particularly when we're seeing the advent of new AI tools all the time. There's a lot of tools that look exciting and really interesting, but sometimes they're based on very little scientific evidence. You know, facial analysis really doesn't have any scientifically robust data to suggest its effectiveness as a predictor for anything useful. So as a predictor for capability or success in role, there's no scientific evidence to back that up. You know, facial expressions aren't universal. They can change due to culture, context. They can change if you have a disability. So they can also be gamed. So those practices are prohibited. The second category, which is the high risk obligations, the compliance dates for those are approaching. So the original deadline for compliance with around the high risk tools was going to be 2nd of August this year, but it's recently been proposed to defer that implementation date to December next year. So the date hasn't officially come into law, but my understanding is it's in the final stages of the legislative process. And that's the category that's really going to impact HR practices if you're using AI in employment, promotion, development, performance management, and so forth.
Yeah, and we will get into that in just a moment. But while I'm just chatting to you, Sharon, first of all, who exactly does this apply to? Because, of course, there's probably a bit of a misconception. We introduced this as the EU AI Act. So the idea that, oh, it's all about people in the EU and we're not in the EU, so it doesn't need to worry us, but that's not the case.
Yeah, it's a really important distinction. The Act has significant extraterritorial impact. So UK businesses really do have to tread carefully, and all businesses outside the EU need to tread carefully. The Act's scope is pretty broad. So it extends not just to the developers of the AI tools and the suppliers of the AI tools and systems, but also to any business that simply uses AI systems, and where those systems affect individuals who are in the EU. So they might be employees, they might be job candidates, they might be consumers, but if those individuals who are subject to the use of this system are in the EU, then the Act applies regardless of where that business is based. So both the provider of the AI tool and the organisation that is using the tool carry obligations under the Act. So you can't just rely on your vendor to manage compliance for you.
Yes, beware. Okay, let's look specifically, as you said, Sharon, at HR, because HR and talent, we might say, are really quite in the firing line here. And Priscila, I know you've been really looking into this about why HR particular is in scope and the kind of tools that we're talking about here that really need looking at carefully by HR teams.
Yes. So once again, if your HR department is already using AI systems to make decisions about hiring, promotions, performance management, or redundancies, then HR falls within scope. Of course, if you are in the EU and you're dealing with employees or candidates, for example, that they are in the EU. A key concern for HR is that many HR AI systems rely on historical data. This data often reflects past workplace norms and biases, including those favoring the traditional full-time male breadwinner worker profile. As a result, AI systems can by default perpetuating existing inequalities by downgrading certain groups. So let me just explain how this happens. So if you're using Workday Adaptive Planning or SuccessFactors functionalities, around workforce planning and scenario modeling, for example, you're almost certain already operating the high-risk territory under this legislation. So, for example, some organizations might use factors such as performance ratings, attendance records, promotion history, leadership experience, skills relevance, or participation in stretch assignments when making workforce decisions. While these factors might appear objective, they can reflect historical inequalities in access to opportunities and workplace experiences, or even absence. If AI systems are trained on such data without appropriate safeguards, they might reproduce or amplify the existing disparities, leading to unfair outcomes to certain groups. For example, a woman might appear less leadership ready if they have historically had fewer opportunities to lead major projects or receive stretch assignments or had more absence from work. Also, the logic is straightforward in the Act. The higher the stakes for the individual, the higher the risks are on deploying AI. And the reason this matters so much for HR is because beyond legal obligations is that HR is the function that knows which tools are in use, and under the Act, as Sharon mentioned, the deploying organization is responsible for, not the vendor.
Yeah, gosh, yeah, we're seeing a theme here. It's your responsibility, it's not the vendor. Yeah. So Priscilla, you've talked a little bit there about some of the tools that HR are using, and they might sort of think, well, I'm compliant there. I've sorted out my tools, but the Act actually is a bit more nuanced than that. So what are some of the other watch outs that HR need to be aware of other than just tools?
Yes, because even when we're looking at the tools, there are different gaps that you need to be thinking about the tools, really. So I kind of list that as 3 gaps. So the first gap is the data problem that I have just mentioned. So the Act requires that training data is what it calls representative. That sounds technical, but the concept is super simple. It means that the data the AI was trained on must statistically reflect the people the system will actually be used on. But here's the problem, as I mentioned before. Most recruitment AI was built on historical hiring data. And in most organizations, historically, more men applied, more men were hired, more men were defined as successful. So the model learned from that and built a picture of what good candidate looks like based on the people who got through before. So, and then it applies that picture to every new candidate and scoring them a baseline that might be favoring men, of course, and downgrading others. And a huge data set does not fix this problem either. You can have millions of data points and still have a fundamentally biased model because the bias was in the labels from the start. So who was marked hired? Who was marked successful? And those labels, they carry the assumptions of every hiring manager who made those decisions before AI was involved. But the problem is most HR leaders have never asked their vendors a single question about this. Who was in your training data? Who was the gender? What was the gender breakdown? What was the demographic profile? How do you know your models performs equally across different groups? And under the Act, those are now legal questions, not just technical, not just ethical ones, and technical ones as well. The vendor must be able to answer them, and the organization using the tool must be able to show that they asked. So that is the first gap. So around the data, the quality of the data, it's super important. The second gap is the human oversight. That is genuine. The Act requires that the people responsible for overseeing AI decisions are properly trained and qualified within the organizations, not just aware that the AI is being used, but genuinely capable of overseeing and modifying the system decisions. What I see in practice is that organizations have a human in the loop who technically could replace the system, but they have no idea how it works. They can't explain what drove a particular score. And in reality, they almost never push back. They push back because they just don't know. And that is not oversight, right? And the Act is explicitly addressing this. And the third gap is about documentation and notification. The Act also requires deployers, so the organizations, to keep logs of AI-assisted decisions for at least 6 months and to inform workers before high-risk AI is used. But most organizations have not done this yet, right? And the practical consequences is this. If a candidate asks why they were rejected, or if a regulator asks to review a decision, you need a record. Not just a general description of the process, a specific record of what the AI output was, who reviewed that output, and what happened next.
Wow. Okay. Thank you. I love the way you've broken that down into those kind of 3 areas that people need to get not just curious about, but very intentional about, and put procedures and things in place. Sharon, let me come back to you and the UK question that we touched on, the kind of scope of this act, because people listening who are leading HR teams will be looking at their organization and thinking, well, you know, what does this mean for us? So for people who have operations in the UK, the US, other jurisdictions, what should they be mindful of?
Yeah, so it's a great point, because I think this applies to a lot of organizations, of course. So the simple truth is, if your company is headquartered in the UK, the US, Asia, anywhere outside the EU, this act still applies to you. If your AI systems, your products, your outputs are used in the EU, or if they affect EU citizens, your company has to comply. So the deployer, you heard Priscila use the word deployer before. That's kind of any individual or business that uses an AI system in their professional activities. The deployer is liable for compliance with the Act, not the vendor supplying the technology, but the deployer. So that means UK businesses can't rely on third-party providers to manage their compliance. You heard about all of the compliance requirements under the Act just now from Priscila. So you can't rely on third-party vendors to manage that if the tool is likely to impact people who are based in the EU. When it comes to the UK doesn't have a single AI law. As you heard, this is kind of the first of its kind, this legislation in the world. So the UK doesn't have a single AI law. The UK government has taken more of a principles-based, sector-specific approach. So UK businesses with EU exposure need to comply with the EU AI Act for that part of their operations.
So people are juggling various different approaches, but absolutely need to be aware of this legislation. Thank you. Priscila, let's come back to you, because you've touched on a little bit already the gender equity implications of all this. You were talking a lot about the way that these models are trained and the data and so on. But if we go even more specifically into the issue of gender, what does the Act mean for organizations who are trying very hard to build fairer talent systems? What are the risks here if they don't act and really kind of get across all the details of this?
Okay, so I think that the one thing I want HR leaders to take from this is that the AI Act and gender equity are not 2 separate conversations. They are kind of the same conversations, and here's why. Most organizations using AI in hiring or promotions are using systems that were trained on historical data. And we have already highlighted that the problem here, that most of these organizations, they are using data that's historical and reflects a workforce where men were more likely to be hired, they were more likely to be promoted, they were more likely to be defined as successful, and so on. So there is so much bias in this data here, particularly around gender. So once again, the model learns from what we had there in terms of the historical data, and then replicates it at a scale, at a speed, and invisibly. So imagine an AI system is trained using years of past hiring decisions. It notices that people with gaps in their CVs were often rejected. So it learns that a career gap is a negative code. Then the system doesn't know whether someone is a woman or whether they took maternity leave, for example. It only sees the gap. But because women are more likely to take time out of work for parental leave, and AI ends up kind of downgrading women. So nobody told the system to discriminate. It learned this pattern from the historical data it was given. So this is called proxy bias. And the problem is that this kind of a bias can be very difficult to spot unless you're actively trying to find it. And that's why the European Commission guidance says employment AI must be tested to ensure it does not produce results that disproportionately affect people based on sex, age, and race. And that is a legal requirement, which means if you're using a hiring tool and it's reproducing gender bias, and you cannot demonstrate that you tested for it, that you addressed it, then you're exposed, right? But the AI is also an opportunity, because those things, they're happening anyway, right? Because we're doing that, but we just didn't have AI kind of bringing all our practices and making that visible. So what AI is doing now is forcing us to kind of mitigate biases, because it's forcing the conversation that many organizations, they're avoiding, because now they need to ask, what is our AI actually doing in terms of hiring? Who is the tool disfavoring? Can you defend it? Before, it was interesting because we could ask these questions, right? But instead of saying AI, we could say hiring managers, right? But now everything is transparent. Everything's going to be out there. So actually, there are lots of positive things here happening as well.
Okay, so I guess if we reframe it, we could see it as an opportunity as much as a risk.
Yeah, definitely.
Yeah, that's encouraging. So there's some good news here, in the way that by the fact that lots of things are centered around AI, it kind of puts it all in one place and puts it under the microscope for us. I like that.
Yeah.
Before we go to questions in a moment, I would love to get into the practicalities of this, some recommendations from both of you, essentially. If HR leaders are listening and they're thinking of maybe 2-3 things that they should do this week that they can really start to take action on, I wonder what comes to mind. Sharon, let me turn to you first.
Right, so some practical recommendations. So a couple of things. Let me start with two. One, I think you need to start with creating an inventory of every AI tool that you have in your hiring, in your performance, in your promotion, in your monitoring, and just check whether or not it touches EU employees or EU-based candidates for roles. So is there an employee or a candidate who will interact with this software or have their data used by the software? So that's first thing, create an inventory of all of your tools. And then secondly, I think review your commercial arrangements. So update your contract, your licensing terms, to address this allocation of compliance responsibilities, so especially if you're deploying AI for people in the EU. So identify a contact person in the supplier organization who can answer the technical terms. So what tests have they done to ensure compliance? Be sure to have a look at those test results, because it is the responsibility, again, of the deploying organization to ensure compliance. So stop using your suppliers if they can't ensure compliance. So there's the two I would say: create an inventory and review your commercial arrangements.
Brilliant. Thank you, Sharon. And let me just, before I come to you, Priscilla, let me just say we're going to come to questions quite soon. So if you have a question for Sharon and Priscilla, again, acknowledging that this is something we have been looking at, we are making very practical and accessible, but we're not subject matter experts. But please do start dropping anything into the comments and we can make sure we address those. But Priscilla, same question to you. What should HR leaders be getting onto ASAP?
Right. So I think that if I expand a little bit more on what Sharon said, I think that first, ask your AI vendors directly, where is your bias testing documentation? What does your training data look like? What human oversight mechanisms are built in, right? So that's very important. Second, do not wait for formal adoption. The deferral to December 2027 is almost certainly the only delay organizations will get. The goalposts have stopped moving. So as Sharon mentioned, you need to make sure you complete your inventory and you're not using providers who are already illegal. They're already providing tools that they shouldn't be working anymore.
Yeah, thank you. I'm keeping an eye on the chat, so if any questions come in, we will definitely address those. If you're watching on replay, by the way, please do still drop questions in, because Sharon and Priscilla and the Shape Talent team are always active on LinkedIn, and we will engage in those comments and answer any questions that come in, or if we can't answer them, direct you to some useful resources, on which more in a moment. But let me just lean into a couple of questions while we just have a few more minutes left, and in case anything comes in. Sharon, one of the things I'm noticing is that issue about sort of responsibility. We've talked a bit about, it's on you, don't rely on vendors. But I guess internally, for an organisation that's starting to think about this, where should they be kind of focusing? We're talking to HR leaders, but I guess some people will be like, well, this is for the legal team, or other people might say, hang on, the tech team are all over AI, bring them into this. And then HR saying, well, but we're being told it's us. So who holds this?
Yeah, I think that's a really interesting question, because it really does feel like it sits at the intersection of different functions. But I think the answer is it belongs to all three functions. It belongs to HR, it belongs to legal, it belongs to technology. And that's kind of part of the confusing element here, who should own it within an organisation. But I think there is a case for saying that HR need to take the lead on this, because I think what's happening in organisations right now is everyone's kind of deferring to someone else. So legal is waiting for IT to tell them what tools are in use, and IT is waiting for HR to define kind of what counts as a talent decision, and HR is waiting for legal to give them a steer. So in the meantime, there is a risk, if you're going around the houses, that nothing is moving forward. So what the Act requires is cross-functional ownership. So not one team solving this in isolation, but everyone working together. And I think HR has a really important role to play here. And the reason I think HR has an important role to play is that the single most important first step under the Act is what I alluded to earlier. It's creating this AI inventory, a kind of a complete list of every system that your organisation is using that touches on hiring and performance and promotion and monitoring. So not just the obvious ones, either not just the big enterprise platform that everyone knows about, but maybe the applicant tracking system with a scoring algorithm that is already kind of built into it, or the video interview tool that ranks candidates, or the performance management system that flags flight risks. So think really hard about where these AI-informed decisions are being made within your systems. It could also be engagement surveys that generate sentiment scores. So map all of your software that the organisation is using that contains either AI components or probabilistic logic. That also includes, by the way, CRMs, customer relationship management systems that have scoring tools, or HR software with any kind of automated ranking. So kind of create an inventory. And that inventory, I think only HR can build, because legal doesn't know what tools the talent team adopted last year. And IT doesn't know that a hiring manager has been using an AI kind of plug-in for the last 6 months. So HR is the team that knows, or should know, where AI is actually touching the people decisions that are getting made. So yeah, you need a legal and an IT team working alongside HR, but I think HR needs to be the one that starts the conversation and really drives that inventory. And then maybe the other thing I would add is that once you've got the inventory, the next question for each tool is pretty straightforward. Does this tool affect anyone in the EU? So not is our company based in the EU, but does our headquarters comply with the law? But are there any people that this tool makes decisions about that are located in an EU member state? That's really the question you need to be asking yourselves, whether they're an employee or a job candidate, for example. And of course, if the answer is yes, then the Act applies to that tool, full stop. So be really clear on what the tools are and where the people are that are being impacted by that tool.
Yeah.
And the thing here that sometimes surprises people when I say is you don't need to wait for what is now going to be December 2027 to act. As Priscilla said, it's unlikely that date's going to get extended. Now is the time to do this inventory, to find out what the issues might be and to do something about that.
Yeah, there's an important window here. When you talked about the scale of the fines, you realise, this is not messing. A question from Jess just before we wrap up, and I don't know, Sharon, whether this will be back to you, or Priscilla, whether you want to come in on this one. I think Jess's point here is, with an inventory, you go to your HR teams, they've got their suite of tools. But what about managers who perhaps independently, they're interested in AI, they're using tools, perhaps, I imagine what Jess is saying is sort of off their own bat, and they might be using tools to help them consider people decisions like performance feedback and ratings. So Jess asking, what advice do you have here? Because an inventory of, like, we pay for this and this will throw up the big ones, but then there might be folks all around the organization tinkering with AI.
Yeah, I'm happy to jump in there. I mean, I think it's you need good governance around this, and of course, this is one of the issues that lots of big organisations are grappling with at the moment. As you're in the experimentation stage, as most organisations are, of using AI, everyone's trying different tools. You need some really strong governance about what tools are allowed in. There needs to be a process to make sure those tools are legally compliant before managers start using them. So I think that's where it probably does go back to IT then to take the lead on what are the controls that you put in place around what tools get into the system that can be used, and to work with HR to make sure that they are compliant from in terms of the high risk categories, and all categories, but particularly the high risk categories of the EU AI Act.
Yeah. Yes. And I guess just one more.
So much. Yeah, Priscilla.
No, just one thing to add. The Act is very specific about the documentation. You need to be able to show the paper trail that proves the compliance and proves the decision that you have taken. So if people are using different AI tools and you don't have this record, how can you prove that you're using the right tool, that the tool has been tested for bias, and so on? So going back to what Sharon said, the governance must be in place. People should not be using tools that they have not been checked properly for compliance.
Yeah, and maybe one more thing. I know we're almost at time, but one more thing I would add there is to really see this as an opportunity rather than a kind of a legislative burden. There is an opportunity here to get the house in order and to make sure systems of fair decision making is fair. And so maybe one test would be to imagine that a regulator came in to your workplace tomorrow and asked you to walk them through a hiring decision that was made using AI. So they would want to know who was the human that reviewed the shortlist. What did they check? Did they understand how the system scored the candidates? What would have caused them to override it? And if they did override it, is that logged somewhere? So if you can't answer those questions, not kind of in an abstract way, but for a specific recruitment decision, then you may not be on top of your obligations for the Act. So you can't just have a human rubber stamp an AI decision. The Act explicitly distinguishes that from meaningful oversight. So maybe there's three things to think about here. The reviewer needs to be trained very specifically on the tool, not on general AI literacy, but on the specific tool, how it works, what data it uses, what we know about weaknesses. So that's number one. Number two is the system needs to surface its reasoning, not just the output. So a shortlist that has no explanation of why certain candidates scored the highest is not reviewable. So the reviewer needs to be able to see what factors drove the score. And the third thing is the deployers, the organizations deploying these systems, must keep the logs generated by the AI system for at least 6 months. So if a candidate asks why they were rejected, you've got some logs, you can go back, you've got a clear audit trail of the decision making around that. So that's not a burden, that is just good governance and good oversight to ensure fair outcomes.
Yes, and perhaps just one thing to add is that if you're retraining the model, retraining the tool, you need to keep testing for bias, right? One-off bias when you develop the tool is not efficient. So a lot of organizations, they keep feeding the system with their own data and their own hiring information and outcomes. So that means you need to keep testing for bias. One-off is not going to work.
So practical, so helpful. And Jess says, yes, very helpful. That answered her question beautifully. So Priscilla, Sharon, thank you so much. I think I love the fact that we're ending this by saying this is not a sort of something to run screaming into the hills. It's like this could be a really great opportunity to stop, to take stock, to think about what is the most positive, the best way we can use AI, the fairest way, and really get in place some rigorous, great tools, a system that supports them, an organisation that feels confident that they're using AI in a way that is fair to everyone, that really supports what they're trying to do with hiring practices and development and so on, but is making sure that still everybody gets the right fair shot at opportunities and promotions and hiring and so on. So yeah, I love that. I think that's a really great place at which to wrap up and say, this isn't about look out, you're going to be punished, but here's an opportunity to really get yourselves confident about AI and know that you're using it for the best outcomes of the people in your organization. So thank you so much. It remains for me to say, if you would like more on this, if you go to our website, Shape Talent's website, we've got resources. We'll drop a link into the chat for the EU AI Act checklist that we have created. This is a checklist for HR and compliance leaders. You can see there dropped into the chat. Really helpful for you to start working methodically through some of those areas that Sharon and Priscilla have so brilliantly outlined. I've said it several times, we're not legal experts, but there are plenty of people who are, so we may well share as well some legal links. We encourage you to find, you know, a reputable law firm that you feel good about, get your own advice, but I really am confident that we've given you some great starting points here. The replay will sit here, engage with it. If you're watching on replay and you've got questions, please drop them in. As I said before, Sharon and Priscilla will more than happily pick that up with you. Of course, you can reach out to them on LinkedIn as well and connect, direct message. We would always be delighted to talk more about this because it's so important. And finally, all that remains to say is we'll see you next month. Next month's LinkedIn Live, it may or may not be as hot, on July the 16th, is at 10 o'clock UK time. It's called From Spend to Impact, Getting Real ROI from Talent Accelerators, because so often people put money behind these things, but do they yield real results? We'll be digging into that question with our very own Professor Rebecca Jones, who's a member of our team here at Shape Talent, and Adnan Ametovic from the German multinational consumer goods company Henkel, who we've done some great work with, and Adnan will have some really good insights on thinking about real ROI from talent accelerators. Do join us for that. The link's not up yet, but if you follow Shape Talent here on LinkedIn, you will see as soon as that drops and you can sign up. We hope to see you then. Thanks so much, everybody. Thanks, Sharon. Thanks, Priscilla. Bye-bye now.